we'll just get going.
Let me see.
Should be good to go.
Good. Did I have we read it before. Here we go. Let me see if I've got it. Well,
Were you,
everybody's here. Nobody has a conflict. Correct.
I was going to say, were you going to remind everybody of their duty under the state government ethics?
That's exactly what I was going to do, but I don't have the language right here in front of me. So I assume that as nobody has uh, uh, recused themselves from this in the past, that they don't feel the necessity to do so now either.
Right.
So Brian, you want to tell us why we had to bring this back as far
Yeah,
as the
yeah,
comment from Audrey Snyder?
that's right. And actually, I see a 336 number. Let me admit this and make sure that we have everybody accounted for. Let's see. I see somebody just joined us from area code 336. Could you identify yourself?
Hey, hey, Brian, it's Ellen Murphy.
Oh, hi, Ellen.
Hey, Ellen.
I see you on Zoom as well.
Oh, did I go in twice? I'm sorry. I'm in my car and I'm trying to figure out the best way to do it. But I pulled over. So
Okay, no, that's all good. I just want to make sure I have the attendance properly noted. Thank you.
Yeah, thank you.
All right. So we have you all saw the comments that we received. We received two comments after publication. And it's probably easiest if I just go ahead and share my screen. Just we're looking at the exact same thing here. All right. So this was, of course, the opinion. The first comment we received was from Audrey Snyder at Ward Black Law concerning opinion number 6. It's the very last paragraph in the opinion that talks about fees. And this particular comment, well, I guess I'll say there is a second comment, and that was from a group of law professors that basically wanted to encourage that this opinion include additional language that would encourage folks to utilize AI to close the access to justice gap. And just kind of to, I guess, essentially use the opinion as a platform to really kind of bring attention to access to justice and how AI could potentially contribute to some efforts in that regard. If not, language, maybe even a full new opinion. So as to the first one, the first comment from Audrey, like I said, it concerns the last opinion. It's about fees, and it's the language that we have in there that refers to the general prohibition that a lawyer can't charge a generic administrative fee for using artificial intelligence in the law practice. I would kind of equate this to essentially, the situation where you have built some AI process into your firm structure, like your firm overhead. And so the opinion was intended to say that if you're using an AI program for a specific client purpose, then and you can specifically assign that use for the client, then that's okay to charge. I would say the very generic equivalent would be, say, Westlaw or Lexis. You're doing Westlaw or Lexis research for a particular client. And if you're able to, if you are getting charged or you're on the plan that allows a lawyer to, search and pay by the case or whatever it is, then you can pass those costs on to the client as long as the client agrees, if that's a part of the fee agreement. But if you have just like a very generic, well, I spend X amount per month on this service. Like maybe if you have kind of and I honestly I don't know what Westlaw subscription plans are these days. I know we have a very generic one for government employees. And so if they're like in our situation, we pay X amount for, up to 20 attorneys accessing Westlaw, but we have unlimited searches, case pulls, all that kind of stuff. And so in that sort of very generic, broad payment, or I guess use of some sort of resource, I would say a lawyer can't necessarily just pass that on to the client, even though the client may or may not benefit from it as like a part of a general research fee. Um, why? Because you don't know. I guess it's this thing that, if you give it to every single client that comes in the door and everybody's paying, say their $20 research fee, depending on how many clients you have per month, you may collect more than you pay. And that means that suddenly your use of this resource, this utility, is in excess of what you pay. Instead, maybe it's just simply a part of your firm overhead. It's become a part of your firm overhead, akin to, electricity, phones, stuff like that. And so that was the purpose of the provision, or I think really the language that she focused in on that. And you see it's here. I'm going to zoom in on it. What she was focusing on, that lawyer may not bill a general administrative fee for the use of AI during the representation of a client. Rather, any cost charged to a client based on lawyer's use of AI must be specifically identified and directly related to the legal services provided to the client during the representation. So I think her proposal or her request, she says, one, we could work around this, but it sounds like they charge a very generic technology fee to their clients. And so it's she's saying that basically if we want to incorporate AI into our provision of legal services, we're going to have kind of a disincentive if we can't pass on that cost to the client. Because now we want to, basically the AI would probably fall under this technology fee. And so we want to, incorporate that here. But the opinion would prohibit that unless they can specifically say, we used AI for this client to accomplish this purpose, and this was the cost of our use of AI that we are now passing on to the client. It's that specificity that I think the opinion permits and really requires if you're going to pass on that cost. So I guess that's the question here. Do you all think that the language in opinion 6 and the prohibition of a very generic just AI fee, because a firm has incorporated AI into its just general function, whether it's case management or drafting services, or anything like that, they are just using AI and they're passing on the cost to the client in the form of a generic fee. Is that permissible, or do we think that the opinion as drafted is the correct thing? And before we get to discussion on that question, I want to say that I asked around with talking with Nicole and Suzanne on our history of advising on general administrative fees, because people have all sorts of different overhead costs, copying, printer ink, stuff like that. And I guess it's been our experience, based upon the number of questions that we get, that a lot of firms charge a very generic administrative fee, setting up the folder type of fee. It's been our opinion that those are permissible in that very generic sense, as long as they're not clearly excessive. And I think the reason is because it is something where the lawyer is kind of taking on almost I don't want to say a bit of risk, but there is the opportunity for a lawyer to incur a loss if they charge a generic, $50 set up the file fee, administrative fee that's going to cover all copies, all printing, just all of that stuff, right? Depending upon how the case develops, you may end up exceeding $50 in copying fees very quickly. But you may end up under that as well. And we recognize that there's kind of that risk. And so if the client agrees to that particular sort of setup, then that's permissible as long as the fee charge is not clearly excessive in violation of 1.5A. And so in my mind, I was kind of thinking, well, how do we distinguish this? And I guess I'll tell you my personal opinion was that I thought this was distinguishable because a generic AI fee doesn't really have with it the risk that the lawyer ends up with the worst bargain, so to speak. You're paying a set amount and you're basically trying to pass that off. And I guess I had those questions of, if you have a monthly fee, does this end up being a moneymaker if you have purchased a program and you own it outright and you pass that cost on to the client, at some point, do you make back that purchase? Is it like, a highway that's charging tolls, and at some point, I know those of you in the Triangle area that have gone on 540 and paid those tolls, it's at some point, has the road been paid for and yet the tolls are still there, that sort of thing. And so it's all kind of a matter of how does this kind of fee fit in? Is this essentially an overhead fee? Should it be lumped in with other permissible administrative fees? Or is this something that's just a little different? So with that said, I've talked a lot. That's the setup. I'd love to hear your thoughts.
So I heard, read Audrey's thing is to have two concerns. One, how do we deal with AI? And two, her feeling that maybe the language we used here was so broad that it prevented them from doing what they're presently doing.
Yeah. Yes,
And
I think so.
I suspect that none of us think that what they're doing presently is necessarily bad at all. I mean, the administrative costs of keeping up with some of the dinky charges and things that they would then have to turn around and charge for, I mean, that's a big part of it too, right? The client that the firm resources taken to try to keep track of these costs, essentially, that they don't consider overhead, that might be a good reason to do it this way, and that in general the client's going to benefit from that, especially at at $175 or something like that. So that was kind of my thought, that she was just as concerned about being so broad in our statement there that they couldn't do what they had proposed. I really don't have an opinion about the AI part, frankly. If they, it is, and the main reason is because I frankly think that most everybody is, at this point, is thinking about the promises of AI, but hadn't seen exactly how they're actually going to use it in any specific thing. So they don't have specific enough, necessarily have a specific enough understanding of what the cost would be one way or the other. So that's kind of my thoughts. I'll be quiet now.
So maybe I can ask the question, does anybody think that the opinion as drafted is incorrect, or maybe is there, like, could the opinion essentially move forward if we took out that sentence? I mean, I think there would still need to be some reworking, to be clear. But could this is maybe the statement that we want to make, that, kind of getting down into the specifics of, well, you can only charge if it's specifically used for a client for a particular purpose and all that. That might be getting too far into the weeds. Is the answer that, a client being billed for AI, any use of AI needs to either be specifically tied to a service for a particular purpose, or otherwise not clearly excessive? Because I see what they're saying, like their fee, their technology fee or administrative fee. So really a technology fee. When you read their agreement, it says an administrative fee because it incorporates copying and printing and all that kind of stuff, as well as the technology that they use to facilitate the client's interaction with the firm. It's just one big lump of external services. And yeah, I generally don't have a problem with it. I think it's like, again, it's the technology stuff. If I'm paying for Office 365 every month, do I get to pass that on to the client because, hey, now you can access your file? Or am I doing it to offer a better service? It's kind of a question to me of like, where does it end? If I'm I'm paying a monthly fee for rental, a rental fee for furniture that is better for my clients to sit in. Can I pass that on? And I feel like that's a really silly and extreme example. I think we would all say, no, you can't do that. That's just something you're doing. But it does benefit my client. Like I think, I don't know, maybe we don't need to go into unreasonable sort of extrapolation of ideas, but the point being, it's just lumping this stuff in as one general administrative fee. I'm not terribly offended by. It just can't be clearly excessive. And so I'm wondering if maybe the opinion needs to be reworded, if it needs to be redrafted to say that any bill for the client on AI needs to be either specifically tied to the client for specifically tied to a purpose, or a particular purpose and a particular service that is contracted with for the client. If you're going to have that direct passing on to the client, of course, with the client's consent. Or it just needs to be not clearly excessive. And clearly excessive is going to be dependent, like you said, Warren, on the development of AI and the pricing structures. AI, it might be monthly, it might be one lump sum. Who knows what it's going to be? So it's going to have to be evaluated individually anyway. So maybe that's the better way to say it, as opposed to this language that prohibits a general administrative fee for using AI. What do you all think of that?
Hey, Brian.
Yes.
This is Ellen. Can you hear me?
Yep. Yes, we can.
Yes. I think that is the right approach. And I'll just throw out an example that I was given when I presented this opinion with Kevin at end of court. It was a lawyer who is using an AI to formulate responses to client inquiries, right?
Mm-hmm.
So it is, while I think there's a lot of unknowns, as Warren said, about what AI will be able to do, I think sort of like the rest of the opinion, the answer is there's no different rule for this as it relates to fees, and the opinion should be clear about that. And so it should say what the bar's position is on administrative fees, because nothing is changing with the inclusion of AI.
Hmm.
Yeah, I want to agree
Right?
with
I mean,
Ellen. Oh, sorry, go ahead, Ellen. Okay, she's on mute. Oh, I wanted to agree with Ellen, but then also add in a caution against this either or thing I hear coming across.
Mm-hmm.
Because I think there's going to be some element of both depending on the client and what you're doing. So, like, there is some pure overhead. Example would be our document management system. It's an option at this point, but has an add-in for AI powered search. And our document management is just a thing. There's no client in particular. They're all going to get touched by that. But then Westlaw, our subscription covers basic search, but sometimes for a particular client, you've got added research that might be powered by AI, but it's not distinct. It's not distinctly the case for any given client where we had to go outside the bounds of our subscription. We would charge through the extra Westlaw cost, but the AI element of the search is baked in. But then last, there's clients who want to use particular AI tools for their particular document review and their particular deal. And that last one is the one I think of where you might have a specific charge for that one client that you wouldn't probably fairly lump in as overhead because you end up with that excessive situation. But all that said, it seems to me like Ellen's fundamentally right that there's nothing different here about the bar rules on costing. It's just a matter of thinking it through, like pretty much everything else with AI in the opinion.
Thank you. No, that's all right. Well, I think that's all. Is anybody else, Lamar?
Yeah, just a quick question. Are there, to your knowledge, any other ethics opinions that deal with the broader issue of administrative fees? What can be passed on to a client basis, what cannot?
There are not. That's one of those things I reached out to, I always check with Nicole and Suzanne. I'm like, all right, I don't know of anything. What do y'all know? What have y'all seen? And it's kind of more of this has just been our general position.
So with that in mind, I would agree with others who have said we don't need to go out on a limb and make a specific rule that relates to AI without any sort of background to understand. Otherwise, more broadly speaking, what's an appropriate administrative expense, what's not. Maybe that's a separate inquiry for a later day.
Right, right. Lori, see you've unmuted.
Oh, I actually agree with that. I don't think we need to nail down the specifics of this because it's not one size fits all. And I think that the not clearly, the not clearly excessive rule is the one to apply here, and people are just going to have to use good judgment unless and until something that's more specific with regard to defining administrative fees comes out.
Yeah, I agree, Brian. It's Craig. I think it's good to be able to have the fee be generic and just an add-on. Maybe it's periodic, I'm not sure. It looked like in this case, maybe there was a one-time $175 charge. I couldn't really figure that out.
Yeah.
But it also allows lawyers to pivot and actually charge perhaps what the actual costs are if you can capture those on a particular matter or for a particular client. So it seems to me that's the best of both worlds.
I'm thinking I'm gonna redraft to see if I can capture this idea. And you're right, Lamar, you said it might be another inquiry for another day, and I think it's kind of this question of what's the difference between overhead that the lawyer has built in for the benefit of the lawyer's ability to offer services, versus some service that is actually utilized really for client benefit. I mean, everything's for client benefit, but still there's some sort of like gray line, a fuzzy line there. But I don't know that we need to identify that now especially because we're in the infancy of implementing AI in our practice. And so it's maybe some flexibility and some understanding is necessary, and we can get specific as things get more specific. So I'm taking this as kind of a charge to redraft that paragraph and see if I can capture the, generic. It can't be clearly excessive, but and maybe it's more so like a permissive. You can pass on those specific things, like Elizabeth was talking about. There's those types of very specific things that you can retain or you can contract with for one client and all that. I think all of that we had previously agreed can be passed on to the client. As for, this stuff that I think we're calling administrative fee overhead, I still feel like we can say that any charge related to a use of artificial intelligence cannot be clearly excessive. We'll just say that. It can't be clearly excessive, but by way of like permissibility for like a direct pass on, you can do that with regards to those specific services for particular clients. So I need to flesh it out on paper, but I've got an idea here to rewrite that paragraph, and I'm going to circulate it to the committee. And if y'all agree with the language, then, we can either meet again to talk about it if we want to, or if everyone agrees, I'll send some instructions as to, how you can note your agreement or any changes or anything like that. But I think that's my charge. Does that sound fair, Warren? Mr. Chair.
Sorry. Yes, that sounds exactly what I would like you to do.
Okay.
I think we're all on the same page there. Thanks.
All right. How about this other comment? The comment regarding use or encouraging the use of artificial intelligence in a law practice. Is there anything y'all want me to do with that?
Well, this is just my visceral reaction to it. I think the opinion that's currently written deals with kind of granular aspects of use in a law firm practice or a lawyer's practice versus kind of the aspirational things that are set out. And to me, those are two different things. That's just my opinion. I wouldn't conflate the two. I keep this very granular piece, the way it is with the modifications that you discussed. I'm not sure what other outlet there is on the aspirational side, but it seems to me those are two distinct and different initiatives.
Thank you. Greg.
Agreed.
Agree, 100%.
I agree, and
Agree.
I thought we had already talked about this. Maybe that they had raised this issue during the big meeting, or maybe we talked about it in subcommittee, but I agree 100%.
Yeah, I think
I
we
agree
first talked
too,
about
and
it.
it's,
Oh, go
I
ahead.
think like, well, no, sorry, I just want to throw in, I think throwing in the positive aspirational element, besides what you all rightly said, is not really maybe the place. It's a bit of a pro AI spin on it that I'm not really ready to do yet.
Me too.
But Lori's right. It came up in the big meeting, and someone, I'm not going to remember who, suggested maybe the professors could write an article for the bar magazine or something like that.
Yeah, I agree. I think there is a potential to share that. I think I'm getting I think it sounds like there's unanimity here about this may be a very fine thing to do, but it's not through a formal ethics opinion. And they can go for it.
Yeah, even their comment doesn't specifically say. It's, once again, it's like there's lots of promise out there, and we want people to use things that work. Well, that's great, but we haven't seen what exactly I don't know, if this turned into HAL and tries to the computer from Space Odyssey 2001 and tries to destroy the planet. I don't think we want to be the ones that encouraged all the lawyers to use it. Not to be hyperbolic.
Yeah, I was gonna say I'll maybe I'll add a new footnote to the proposed opinion. State Bar does not take a position on encouraging AI due to the potential for it to turn into HAL and destroy the planet.
Not to put Ellen on the spot, but obviously that's the world that you live in. What's your take, Ellen? If you're still on.
She is on, but she's muted.
Okay.
Yeah.
Well, I know she's driving, she's traveling, so
yeah.
maybe running some difficulties there. Well, anyway, I think we're all in agreement. I will, for whatever it's worth, you guys are the decision makers, but for whatever it's worth, I agree with you. I think we can keep these things separate. So, all right. Well, I will go ahead and make those changes and circulate again. Is there any other aspect of this opinion that y'all wanted to, I don't know if you took a look at it and you're like, oh, this actually jumped out at me. I think now would be the time, but otherwise we can make that change and we'd need to republish again in July because it would be a substantive change. But that said, is there anything else that anybody wants to talk about? All right. Well, then, Mr. Chair, I think we're done with our discussion.
Sounds great. Good job, Brian, as usual. I appreciate it. Thanks, y'all.
All right. I'll be
Hey,
circulating.
y'all, it's Ellen.
Hey, Ellen.
Hey, I'm sorry. My car won't let me unmute unless I stop.
All right.
It's a smart car.
Artificial intelligence,
right?
maybe.
Right.
Craig, I appreciate you asking.
You there,
think
Ellen?
the professors would be.
Yeah.
I'm here.
Yeah, we can hear you.
Can you hear me? Yeah. Craig, I think the professors would be flattered to have their comment acknowledged and then to say, we have found this venue for you if you'd like to write something. I think that would be important, and I think it would be good.
Right.
No, I agree. I wouldn't want to give them the back of our hand, so I think that's a good suggestion.
Yeah. All right. Well, I can do that.
Thanks.
I can reach out and, even to suggest something like if they draft something, it could be submitted for consideration as a State Bar Journal article. You know, that might be a great opportunity in that regard. So anyway, I'll respond to them and let them know what the collective thought was here. And in the meantime, redraft and we'll just go from there. All right. Thanks everyone. Thanks for making your time
Thank
making the time
you.
today.
Thank you.
Good luck,
Thank y'all.
everybody.
Thank you.
Bye.